LSPC, Legal Services for Prisoners with Children, is a legal support center. We do trainings such as this. We do technical assistance for qualified legal services providers, and we do advocacy support in a range of fora, including legislative advocacy, administrative advocacy, some impact litigation, and other forms of legal support advocacy. So feel free, especially if you're a qualified legal services provider, to reach out to LSPC after this event. My name is Eric Sapp. I'm a staff attorney. I do all of the aforementioned sorts of activities. I'm joined today by my colleague, Nateel Sharma, and he's going to introduce himself, and then he's going to kick off the discussion. Since Nateel may need to hop off the call a little bit early, I suggest if you have questions specifically directed to Nateel's presentation, that we'll take those after he speaks, before we kick it over to me, just so that we make sure that we get those questions in. And also, if you want to write questions in the chat, we can read those out. So Nateel, why don't you introduce yourself and get us rolling? Thanks.
Okay. Good afternoon, everyone. My name is Nateel. I'm an Elder Freeman Policy Fellow at LSPC. And a little bit about me, or first, thanks everyone for being here. Definitely spending your time with us. It's really important that we open new avenues to help incarcerated folks in these similar situations. So a little bit about me. I am formerly incarcerated, and after being released in 2023, I um, I traveled to Hawaii, and going to Pearl Harbor had a really tremendous impact on me. And um, while being there for that week, just seeing everything live in person impacted me in such a way that I wanted to seek out some type of work for the Navy myself. Um, so I went out to a recruiter locally here in Hayward, and I told the recruiter my situation, and he said that it's possible that I could get in, but would need clearance from the sergeants. And after going through the entire process, giving them all my rehabilitation from the initial point of when I was charged back in 2014, I showed 15 years of rehabilitation and a bunch of support letters from people like former State Senator Nancy Skinner, Lori Wilson's office currently, and yet after I provided all that, they said that I had a 20% chance of getting in, and I was really bummed about that. And also, I know there's two different types of clearances, I believe. One is the public trust and one is security clearance. So depending on the position that you're trying to go for would require one or the other type of clearance. And even as a someone who would want to go into the Navy Reserve as doing policy work, which is a civilian role, it would require like secret clearance due to the type of information that would be shared. Um, and uh, so it was really difficult to get cleared because of my criminal background. Um, and I hope we can create some avenues for being able to gain employment in these spaces, even as a civilian. Um, yeah, thank you.
And Nateel, if I ask, in addition to the support letters, what were the evidence of rehabilitation that you collected and
Sure.
submitted?
The rehabilitation was from first from the so from 2014 up until 2023, I was released under good behavior. I was resentenced under good behavior and therefore released. And so I was originally notified by Nancy O'Malley, the DA at the time, and she had wrote a letter to me saying that the DA's office had um been keeping an eye on my rehabilitation status, and that they seen that I was doing exceptionally well, and would consider resentencing me in a few years after that. And in at in 2023, I was resentenced by Pamela Price. So uh that note in itself was really helpful. All the classes that I was a part of, victims awareness, anger management, all of these classes I was a part of, and graduated from, which helped too. And um so those were some of the things that um were done.
Does anyone in the audience have any questions for Nateel? He'll be sticking around for a little while more, but he might need to leave before we get to the Q&A at the end. So feel free to pose those questions now, or you can pose them later, and can always follow up through email. Also want to encourage folks, if you want to put your name and affiliation in the chat, and what your interest in the program is, if you care to. So I'm going to go through some of the background of statutes and regulations that relate to the waiver process and restrictions on joining the military in the U.S. Due to criminal record backgrounds, and hopefully spark a discussion about that. So I will go ahead and share my screen. Okay. Hopefully you can see my screen here. So this is a lithograph created by Nicolas Toussaint-Charlet in the aftermath of the Napoleonic War. On the left-hand side, there are prisoners of war of the Austrian forces, and on the right side, French forces moving toward the front lines of a battle. The scholar and philosopher Ian Buchanan, in his treatise on militarism, written at the time of the while the Iraq War and insurgency was still in full swing in the mid-aughts, although the article is mostly about Vietnam and its legacy, writes the following: militarism offers upward mobility and social approbation to the working poor as its most potent recruitment strategy. To this, we can add also that the phenomenon of mass criminalization from the 70s and 80s and 90s, and although somewhat rolled back that trend in the past decade or so, continues to this day. Mass criminalization operates in the opposite direction than this social approbation recruitment strategy by limiting who can serve in the armed forces. Just as a basic background, when we talk about the U.S. military forces, we have in mind several different components: the regular Army, Navy, Marine Corps, Air Force, Coast Guard, and now the emerging Space Force. And the authority for the Secretary of Defense to recruit for these forces is outlined in Title 10 of the U.S. Code, Section 503. And there's also the National Guard, which is a hybrid state and federal network of forces. There's a National Guard for each state and also several territories. So there's over 50 different National Guard, units, so to speak. And they are considered an organized militia under Section 246 of the U.S. Code. We're going to be focusing here on the regular armed forces. Things are a little bit more complicated with the National Guard. We won't get into that. Although obviously the National Guard is in a lot of media attention these days due to its utilization and indeed misuse for purposes not particularly related to national defense, but for political grandstanding in regard to immigration enforcement. Chalmers Johnson, a former intelligence official and scholar of the U.S. military, describes what he calls an empire of bases. And in the next slide, which I'll get to in a moment, which was a map created by the scholar David Vine, it sort of gives a visual depiction of the geographical scope of what this entails. So it may be a little hard to decipher this at first, but on your screen there is a global projection that has a series of dots and circles depicting U.S. base presence. Now, the large yellow circles are areas in which there are 100 or more bases, and the medium-sized yellow circles are 50 or more bases. The larger, though smaller than that, red circles are 10 or more bases, and then the dots are smaller than that. So there are hundreds and hundreds of bases with variable concentrations and reflecting the historical legacy of past wars, and in the case of the encirclement of China, the prospect of future wars that defense planners have in their sights, and the prevalence of a number of smaller in scale, but geographically significant bases in Africa, one might think reflects questions of resource, potential conflicts over resources or existing conflicts over resources needed for the technological economy of hypermodernity. Let's see. Whoops. Pardon me. Having a little troubles with the slides. So some constraints on the freedom of speech that I have in giving this talk is that whoever has intent to interfere with, impair, or influence the loyalty, morale, or discipline of the military and armed forces of the United States is guilty of a felony under federal law. Which is not to say that I have any intent of doing that, but it does show the outer limits of free speech when talking about questions of military recruitment and counter-recruitment, especially with respect to existing forces. Anything that would constitute urging insubordination would probably fall outside of the Brandenburg Standard and could be insightful to unlawful conduct. Now, Title 10 of U.S. Code, Section 504, lists certain what it calls persons not qualified to join the armed forces, and that includes persons who are, in its language, insane, intoxicated, or deserter, or who have been convicted of a felony may not be enlisted in armed forces. However, that same section authorizes the Secretary of Defense to authorize exceptions in meritorious cases for some of these categories, including felony convictions. And the process of those exceptions we're going to get into in a moment in some detail are spelled out in the Code of Federal Regulations. The statute 504 also limits eligibility for either citizens, lawful permanent residents, or persons who are under one of the free association agreements with Micronesia, the Marshall Islands, and Palau. And also subdivision B2 spells out other modes in which the secretary can authorize exceptions for the national security interest. Continuing with section 504B, paragraph 3 envisions background investigations and security and suitability screenings. This relates to what Nateel was talking about earlier. And ultimately, the Secretary of Defense is in charge of setting the policy for that and does so through regulations. Um, 505 sets out age restrictions. You'll notice that 17 is set as the minimum age. This is one of the bases on which U.S. accession to the Convention on the Rights of the Child has been a sticking point in international relations and international law for a few decades now. Now, the person who's under 18 needs to have consent, though, of a parent or guardian. Um, 505B has to do with re-enlistments, and then specifies in subdivision E that Space Force has its own special eligibility criteria. 506, and this is important, states that during a war, someone can be enlisted for until 6 months after the termination of the war. In an era in which we have potentially unending wars or wars where the status of something as a war or the duration of it is somewhat indeterminate, potentially this gives the administration the ability to extend service a lot longer than the ordinary time limits. Now, there's restrictions in the law governing Department of Defense funding, not necessarily restricted to enlistment in the armed forces, but receipt of Defense Department loans in general for persons convicted of certain offenses. Section 985 of Title 10 restricts burial-related benefits for certain criminal convictions. And importantly, the statutes expressly restrict enlistment in the armed forces or commissioning as an officer in the armed forces for persons convicted of specified sex crimes. Now, Department of Defense Instruction 1304.26 from 2015 states, quote, the armed forces are responsible for the defense of the nation and should not be viewed as a source of rehabilitation for those who have not subscribed to the legal and moral standards of society at large. This word moral comes up in various places, and sometimes the waivers are referred to as moral waivers, even though the focus is particularly on criminal law and its administration. Here's a somewhat difficult to read on its own face chart, but it's helpful once you get into the weeds, and it will be included in materials which will be available for you. This was prepared by a firm in DC called the National Security Law Firm, and this is describing the eligibility for waivers depending on the classification of offense, and we'll go into what those are under regulations in a moment, and the number of offenses. So, for example, if one has, one major misconduct, which is basically equivalent to a felony, unless it's within one of the classes of non-waivable offenses, the director of military personnel management can issue a waiver. If one has two of those, there's no waiver. If one has what's called a misconduct offense, which is usually you could think of as roughly equivalent to a misdemeanor in most instances, one of those does not even require a waiver, but 2 to 4 does, and 5 or more renders somebody ineligible. And then similar, there's traffic offenses and what they call non-traffic offenses, which is could either be infractions or could be sort of low-level misdemeanors, have different requirements. Section 66.6, the Code of the Federal Registry, outlines in detail the eligibility criteria. And those include age requirements, citizenship requirements, which we already mentioned in their statutory form. The regs also go into details with education. High school diploma is desirable but not mandatory for enlistment, and it spells out recognition of various alternative credentials. There are aptitude tests given with specific testing requirements. Dependency status is an interesting thing. I don't know if this is on many people's radar, but if you have 2 or more dependent children under 18, you need a waiver for that. If married, and if unmarried, even one dependent child requires a special waiver for enlistment. I think their military is generous in its issuance of such waivers, but the fact that they are required is quite notable. I don't actually have the ability to see the time when I'm on this screen, so please feel free to cut in if it looks like I'm getting toward the end of my allotted time. Paragraph 8 gets to the heart of the matter that we're particularly interested in, and that has to do with waivers for character and conduct. The underlying purpose of enlistment is to minimize, according to the regs, to minimize entrance of persons who are likely to become disciplinary cases, security risks, or likely to disrupt the good order, morale, and discipline of the armed services. And the military services, quote, should not be viewed as a source of rehabilitation for those who have not subscribed to the legal and moral standards of society at large. This echoes what we encountered in the Department of Defense issued instruction. So section 66.6b, 8, and then subparagraph 2 notes that someone who has a significant criminal record creates a prohibition. However, a waiver in meritorious cases can be issued. And then it refers to 66.7 for the details about that. Again, for certain kinds of sex offenses, no waivers are allowed. Subparagraph 4 and 5, respectively, non-honorable discharges from the military can be a bar from, re-enlisting. And in subparagraph 5, there's this catch-all antisocial behavior, which gives flexibility to the Defense Department to use a substantial amount of discretion, it would seem, from the face of this regulation, to exclude persons from service. Drug and alcohol dependence or quote unquote abuse, according to paragraph 9, is incompatible with military life and does not meet military standards, and requires a screening process to identify those with quote unquote history of drug and alcohol abuse. 66.7 of Code of Federal Regulations, Title 32, governs the waivers and specifies that waivers are not automatic, but are case-by-case individual determinations for those eligible. Medical waivers are required for those who didn't meet the medical screening requirements, and dependency waiver, again, refers back to the section restricting those with two or more than two dependents. Conduct waiver is the key topic for us, and this verbal description sort of corresponds to the chart that I showed earlier, where a waiver is required for one major misconduct offense or two misconduct offenses of a non-major sort, or for a pattern of offenses. And corresponding to the drug screening process in 66.6, section 66.7 provides for what it calls drug waivers. Now, the classifying of conduct offenses has to do with what counts as a major misconduct offense or traffic or non-traffic offenses. And the regs give some guidelines about how the military authorities are supposed to classify these different offenses, which again, often or most of the time come from state law in the various jurisdictions. So examples of traffic offenses, you'll see on the screen, in everything from bicycle violations to driving on the shoulder, or driving without a license, hitchhiking, improper blowing of horn, things like jaywalking, and more traditional things that you think of for traffic offenses like speeding, noise control ordinances also. What they call non-traffic offenses, altered driver's license or identification, committing a nuisance, curfew violations. That's significant also to note that juvenile offenses are count for purposes of the federal military eligibility rules, and also we may come back to this later. Expungement, state level expungement doesn't erase the offense for purposes of the armed forces eligibility rules. Other non-traffic offenses: drunk in public, just disturbing the peace, harassment or stalking. Presumably this is not like felony level stalking, and various more that you see on this list. Unlawful assembly, interestingly, is one. Vagrancy, vandalism. These are often offenses along with disturbing the peace that can, especially unlawful assembly, that is often used to penalize protesters. Now, the more serious but not major misconduct offenses are listed from 300 on in this series, including aggravated assault, carrying a weapon on school grounds, criminal trespassing, desecration of a grave, looting. Those are certainly offenses that could be relevant to the military, looting, for example. Now, interesting, the classification 308, domestic battery or violence not covered by Title 18, Section 922, or the Lautenberg Amendment. That distinction is is important because things that are listed in the Lautenberg Amendment under domestic violence crimes are non-exemptable offenses. So if something is a domestic violence offense within the scope of the Lautenberg Amendment, that can't be waived. Reckless driving, reckless endangerment, resisting arrest. These are examples of misconduct offenses that, again, are waivable unless you have 5 or more. Now, major misconduct offenses, these, if you have more than one, it's ineligible. Or if you have one plus a certain number of non-major offenses as well, can render someone ineligible. Arson, assault with a dangerous weapon, bribery, burglary, carjacking, criminal libel, extortion, hate crimes, and a whole number of other offenses, manslaughter, murder, certain drug offenses, rape, riot, robbery. And terrorist threats is another one. Now, let me see if I can, I'm going to stop share for a second just to go back to that original chart. So now that we have a sense of what the different classifications are, let's see.
We also do have some questions for Nateel, Eric. I don't know if you want to do.
Yeah. You can go ahead and ask those.
Okay, there's one in the chat that I think you already answered, but I wanted to say it out loud. Someone asked, what was the response time like? Was there additional back and forth after submitting rehabilitative evidence?
Yeah, so in total, it's been about 3 weeks since we last spoke, and there has been no updates or anything. In total, from the time when I went into the office for where the recruiter was at till this point, it's been a month and 2 weeks. So that's been the trajectory of time so far.
And then we have one in the Q&A. They asked, do you have any recommendations for aggregating those supporting documents? Who should people be reaching out to, and at what point in the rehabilitation?
Sure. If I understand it correctly, for people who are formerly incarcerated or incarcerated and they have an interest in wanting to join, they should start gathering all the rehabilitation things. And it'll be, I feel like it'll be easier once you're released to continue compiling more rehabilitation stuff and just add on to the documents, the rehabilitation that you've been doing inside. And hopefully that could be, satisfactory.
I think that was it for now. Thank you.
Okay, thanks. So I'm going to go back to that slide that described the that shows the different classifications of offenses. Let's see. Okay, so again, if you have one of the major misconduct offenses that is waivable, 2 of those no waiver. Of the misconduct offenses, with 1, there's no waiver even needed to be sought, but if you have 2 to 4, it can be waived. 5 or more, no waiver. Of the non-traffic offenses, up to 4, and this means that the non-traffic offenses that are between what they call misconduct offenses and traffic offenses, up to 4 of those, no waiver required. between 5 and 7 battalion commander can waive it. 8 or more, no waiver. Traffic offenses, up to 4, no required. 5 or more within a certain time period requires a waiver. Now, there's also it's a lot more complicated than this, because obviously someone might have one major misconduct event and then one misconduct event, and so the permutations are obviously complicated, and there's like a guideline formula for those combinations. Two, if you do have a specific question about that, feel free to email me afterwards, and I can get you more detailed guidance on that as well. Just give me a moment to get back.
I have a question, Eric.
Yes.
So if you have one major conviction, you fall in the 1 to 2 bracket, it would be waivable, right? Potentially, or does the amount of time that you serve in prison account into whether they determine whether you're suitable, or like you can go through with the waiver process or not? Or
So that's a good question. So the way they define the categories or the classification of offenses is not in terms of time, except to the extent that whether there is a correlation between whether something is considered a felony or misdemeanor under state law. Could sometimes is whether something is servable by a year or more, or a year or less. But it's more like the qualitative definition of the offense rather than the quantity of sentencing that is the key. But also, since we're talking about sentencing, things like, again, a dismissal of a charge constituting an expungement is not going to erase the significance of that event as a conviction for purposes of the application of the military rules, although it will go into the application of discretion as to whether the person is suitable. So in other words, like, the expungement of something doesn't get rid of an offense if it would otherwise render them ineligible, but as long as they're still eligible, the fact of an expungement can weigh as a discretionary factor in the person's favor. Similarly with a pardon, similarly with diversion, that's a controversial point, which given like a diversionary program in lieu of a sentence can be considered a conviction for these purposes.
I think you're muted, Eric.
Okay, I hope you were able to hear me when I answered Nateel's question.
you
If
were
not,
muted, Eric.
I was muted through the whole answer to your question. Is that?
I believe so. I believe so. Yes.
No, I could hear you.
Okay.
Oh,
When I was
I
talking
couldn't.
about when I was talking about expungement and diversion, were you able to hear that? Jocelyn? Yeah.
I could hear on my end, yeah.
Okay. Great. So, okay. So supposing someone, succeeds in the waiver process and enlists or is commissioned. So then there are serving in the armed forces, and this could be described as a form of voluntary servitude. So those of us in the space of reform to criminal law and the administration of punishment, the question of involuntary servitude is at the forefront of a lot of people's thinking and a lot of people's policy efforts. And one of the exceptions traditionally, recognized in American law through various judicial opinions for the past century and a half to the ban on, the main exception written into the Constitution and various states' constitutions to involuntary servitude is criminal punishment. Another one that's not written into the constitutional text but is inferred as excluded from the ban on voluntary servitude by courts is compulsory military service in those scenarios where a draft is instituted. For example, in most recently in this country around the time of the Vietnam War. That is to say that compulsory military service is not considered unlawful involuntary servitude in American law. Now, of course, when one volunteers today the professional armed forces are an entirely voluntary military force, and so someone chooses ostensibly freely to join the armed forces. But once they join, they sort of have voluntarily surrendered a substantial part of their freedom, and so you could speak of it as a form of voluntary servitude once one is there. So just to note a few of the contours of that, Section 892 of Title 10 of the U.S. Code, which is captioned "A failure to obey order or regulation." Any person subject to this chapter who, one, violates or fails to obey any lawful general order or regulation, two, having knowledge of any other lawful order issued by a member of the armed forces, which it is his duty to obey, fails to obey the order, or three, is derelict in the performance of his duties, shall be punished as a court-martial may direct. This is Article 92 of the Uniform Code of Military Justice, which governs the armed forces. And so, disobeying a lawful order is an offense punishable through court-martial. The flip side of that, though, is what about unlawful orders and regulations? It's generally recognized that not only is it permissible, but in some instances there's a duty to disobey a manifestly unlawful order. For example, an order to summarily execute a civilian would be an unlawful order, and it would be the duty of a service member to refuse to obey that order rather than to follow it. On the international level, that principle, which again, as I say, is recognized in American law, although the scope of it may differ between certain interpretations by international authorities and U.S. interpretation of its law. But as articulated by the International Committee of the Red Cross in its guideline codification of international humanitarian law, which it calls Rule 154, every combatant has a duty to disobey a manifestly unlawful order. And the Committee of the Red Cross opines as follows: the state practice establishes this rule as a norm of customary international law applicable to orders given in both international and non-international armed conflicts. Now, again, you'll notice that it's phrased in terms of manifestly unlawful order. And then it notes as a caveat, quote, with respect to the position of a combatant who disobeys an order that is unlawful, but not manifestly so, practice is unclear. And when they say practice is unclear, they mean the practice sufficient to establish something as a norm of customary international law and therefore binding on all parties irrespective of treaties. So in other words, if an order is manifestly or clearly unlawful, there is a duty to disobey. But if it's in, let's say, the person believes it's unlawful, but it's kind of in a gray area, then it's not, it's not governed by this rule of international humanitarian law or laws of armed conflict. Now, another concept that I just want to flag that circumscribes the limits to freedom of the form of voluntary service that military service constitutes is conscientious objection. So most of us probably familiar with the concept of conscientious objection in the case of someone objecting to a draft. But it is also possible for someone to raise a conscientious objection claim after they've already been enlisted or commissioned in service, if they can meet the standards. And that requires generally a principled objection to all war and not merely an objection to the policies encoded in this or that particular military operation. So it's a fairly fact-specific and person-specific interpretive operation. It's grounded in the First Amendment's, you say most solidly grounded in the religious free exercise aspects of the First Amendment, but courts have also held that non-religious, secular, philosophical, moral, ethical principles can also qualify for conscientious objection and First Amendment recognition of that. Now, another topic about the intersection of, shall we say, morality or views of morality and military service. And this is a current event hot button issue. Earlier this year, after the second term of Trump began, he issued a string of controversial executive orders, including one titled Prioritizing Military Excellence and Readiness from January of 2025, Executive Order 14183. And the first section of that describes the purpose as follows, quote, "The United States military has a clear mission to protect the American people and our homeland as the world's most lethal and effective fighting force. Success in this existential mission requires a singular focus on developing the requisite warrior ethos, and the pursuit of military excellence cannot be diluted to accommodate political agendas or other ideologies harmful to unit cohesion." End of quote. Now, should certainly be the irony should be lost on no one that this order itself embodying a political agenda and ideology of a rather strong form of ideology, it presents itself in the name of overcoming political agendas and ideologies. That section continues, quote, "Recently, however, the armed forces have been afflicted with radical gender ideology to appease activists unconcerned with the requirements of military service like physical and mental health, selflessness, and unit cohesion," end quote. And then section 2 spells out the president's policy, and this part is all underlined in the original issuance of it. 3 sentences of underlined text displaying the dignified skill of the president's writers. Quote, "It is the policy of the United States government to establish high standards for troop readiness, lethality, cohesion, honesty, humility, uniformity, and integrity. This policy is inconsistent with the medical, surgical, and mental health constraints on individuals with gender dysphoria. This policy is also inconsistent with shifting pronoun usage or use of pronouns that inaccurately reflect an individual's sex, end quote. And then the executive order goes on, ordering administrative officials to implement this policy. Now, what the second sentence of the policy is trying to say by the inconsistency with constraints on individuals with gender dysphoria is anybody's guess. I don't know that the ideological predilections of the author of this were could be fit into, or I don't know if the grammatical understanding of the English language of the author of this was expansive enough to fit their ideological ambitions. But in any event, the third sentence is quite interesting with its specificity in targeting pronoun usage and disagreeing with the quote unquote accuracy of pronoun usage. Now, unfortunately for the president, this is not simply a matter to be decided by the president's fiat, because there is a statute in Title 10 of the U.S. Code that specifically governs gender identification, and that's Section 986, which is still good law and says the Secretary of Defense may not require or prohibit a member of the armed forces or a civilian employee of the Department of Defense to identify the gender or personal pronouns of such a member or employee in any official correspondence of the department. In other words, the administration can't require someone, whether they're in the armed forces or a civilian employee, to misidentify their gender or to use the pronouns that the administration prefers rather than what that individual identifies as their preferred gender pronouns. And that is a matter of statutory law. So I've reached the end of my slides, and I have my email on the screen and hope that anyone who wants to continue the conversation afterwards can reach out to me. And do we have any comments from the audience or questions from the audience?
I don't see anything right now, but we can give it a minute.
And again, as a reminder, if you want MCLE credit, fill out the form for that. And please also fill out an evaluation form. And Nateel has also put his email in the chat. So if anyone wants to reach out to him, you're more than welcome to. Again, thanks everyone for attending, and thanks to LAAC for hosting. It's always a pleasure to do these. And I will turn it back over to Jocelyn for her outro.